Good evening, this is Salam Immigration. Today is the 21st of September 2019. Today I want to share with you something very important for migrants, which is a judicial review. It's quite common that sometimes there is a harsh decision with no right of appeal or no forum available to challenge the action, and in such cases, the only thing available would be a judicial review. Judicial review is normally a function of the High Court, but when the immigration cases were too many, the system was overwhelmed, so the High Court decided to, and the government also agreed to change the rules and delegate that function to the upper tribunal only for immigration purposes. Some of the functions were not delegated, like lawfulness of detention is still with the High Court. The number of refusals that we get nowadays from the Home Office, when the application is refused, they would say that the application is a rubbish claim. That is, they say this is a clearly unfounded human rights claim, and therefore it is certified so that there is no in-country right of appeal, meaning thereby that the person cannot file an appeal in country. They can only challenge the decision in an appeal. When they go back to their own country, only then they can file an appeal. Effectively, it means that the case is lost. When people go back, it becomes very difficult, and it is common that a very small percentage would still challenge the case when they have already left the UK. They would have lost the hope of getting anything while they are overseas. There are practical difficulties as well. So the migrants tend to challenge their decisions somehow in country, and the only forum for them would be a judicial review in the upper tribunal. Upper tribunal is a senior tribunal, and when you make a judicial review claim, it is very important that the judicial review has been properly drafted. The grounds are sensible and strong. If it is a weak case, then there's no point in spending a lot of money. Like the normal price, say, starts from £3,000 for the judicial review that you pay to the solicitors. Uh, the barristers would charge in addition thereto if there is a hearing. The court fees are, however, very nominal. It's just 154 for up to a paper hearing stage. The decision should be such that no caseworker or decision maker would have reached that decision on the basis of the papers that were before him. That is, there should be nothing like some more evidence to support the case. In judicial review, we can only challenge the decision on the basis of whatever was before the decision maker when the decision was made, and not that there were some other points which you may now wish to present to the upper tribunal. You cannot do so. If there are no reasons, then it is advisable that you make a statement under Section 120 or a new application to the Home Office to present the further new evidence or further reasons, and then if they still do not do anything or refuse it, then we go for a judicial review. Before lodging a judicial review claim in the upper tribunal, it is a protocol that you issue a pre-action notice to the Home Office through their judicial review allocation hub, which is a different team. They are not the caseworkers who have dealt with your case or their colleagues. The pre-action notice would tell them that these are the grounds on which we intend to go for a judicial review unless you review your decision or provide the relief. In the pre-action notice, you also suggest what relief you are asking for. So, if within 14 days the Home Office or their judicial review team do not provide you with a satisfactory resolution of the problem, then you are at liberty to make a judicial review claim. But the whole process should not take more than 3 months. It is 3 months from the date of the decision, not the date when you have received it. If there are any delay or whatever, it has to be 3 months from the date of the decision. Some of the actions would be such that there is no refusal, and there is no certification that these are human rights claim or claims which are clearly unfounded, and still there can be judicial review, like in the case of removal or in the case of detention. So, if a detention is sought to be challenged as unlawful, then there has to be judicial review in the High Court, not the upper tribunal. The upper tribunal would deal with the judicial review claim initially on papers only. When the judicial review claim has been filed with the upper tribunal, you will have to serve a copy to the Home Office, and then the Home Office uh, lawyers, government legal department, they will put their defense and acknowledgement of service to the upper tribunal, saying why the judicial review should not be allowed to proceed, why the permission should not be granted for the case to be heard for a full hearing. So after the Home Office have given their response to the upper tribunal, then the judge of the upper tribunal, sitting alone, would look at the grounds of judicial review, would go through the response of the Home Office by way of their defense, and then decide whether to grant permission or not. Permission means that a judge would say that the case is good enough for at least a full hearing. So, so this is done only on papers. If a judge thinks the case is not good enough, there will be no permission, and that means that you should not be allowed to go ahead with. You should not be allowed to. You should not be allowed to go ahead with a full hearing. If that is the case, then you have always the right to ask for an oral hearing. Sometimes the judge would, while refusing permission, also say that the claim is totally without merit. If there is a certification that it is totally without merit, then there will be no opportunity of requesting an oral hearing. If there is the opportunity of oral hearing, if it is not being certified as such, then you can make an application, a very simple application, only intimating the whatever that you wish for the matter to be heard in oral hearing, and then you can engage a barrister when the date comes, and your barrister or representative will go to the upper tribunal and present your case and explain to the judge why permission should have been granted and that the permission refusal is not correct. In most of the cases in such a hearing, permission hearing, what we call it, the Home Office is also interested and is represented. They also send in their barrister representative to defend their case why permission should not be granted. If at the oral hearing the judge still dismisses the case and says no, permission was rightly refused, there should be no permission, then the judge will also award costs. If the Home Office have made an application in their defense to the judge saying that they have incurred so much expense in dealing with the judicial review claim, then the judge, while dismissing the permission application, would also grant costs to the uh, Home Office so that they can recover it from the claimant. If a case is granted permission in the oral hearing, then the case proceeds to a full hearing, meaning thereby then there will be directions on how the case should proceed. And in that case, there will be barristers from the both sides and there will be all the procedures being followed. It will be a proper full hearing. Normally, what happens when it is going for a full hearing, both the parties would be conscious about costs because the costs will escalate if we go for a full hearing, and the party who is losing, they will not only pay to their barristers and solicitors, but would also pay to the other party for their solicitors and barristers as well. So it is very common that when permission is granted, the Home Office is minded, rather they are more interested in getting the matter settled out of court. That means that the Home Office will offer you a settlement by way of a consent order, the terms of which normally are that they would say that we will reconsider the decision within, say, 90 days of the sealing of the consent order, and we will give you your costs incurred so far. So, generally, the other party is also happy with this outcome, although the reconsideration can again result in a refusal. Obviously, if there is reconsideration, the caseworker will have to keep the comments of the judge and the reasons given by the judge for granting permission in view while making a reconsidered order. But if there is something very strong that the Home Office feels and they still want to refuse the application or refuse to grant any relief or to maintain their previous decision, then you can again make another judicial review claim. It is important to understand that even when you win a judicial review in the full hearing and after everything, the judge would not say that this person should be granted a visa or leave to remain. What they would say is that the decision that has been challenged is irrational, unlawful, illegal, and they will quash it, they will cancel it. That means there is no order there, and the Home Office would, in any case, have to pass a new order, and that is also like a reconsideration of the matter. So that's why the consent orders are generally entered into by both the parties, because that is the outcome that would have been even after a full hearing. The fees would be a little more if you want to take the matter further from the paper hearing. Like if you ask for an oral hearing, there is a fee of 385 payable to the court, and if permission is granted, then another 385 will have to be paid to the court to make the full payment of 770 for a permission. Uh, sorry, to make a total of 770 for the case to proceed to a full hearing. The threshold for judicial reviews to uh, succeed is a bit high. It's not like an appeal in the first rate tribunal where you present new evidence, more evidence, present witnesses, witnesses are heard, and cases thrashed threadbare and more detail. But in the judicial review, there is no evidence, further evidence. There are no witnesses. No one is giving any evidence. So the system is a bit different. So the judge is only looking at whatever was before the caseworker and without listening to any witnesses or evidence. So it doesn't go into that much detail. They are not there to find out whether the action was right or wrong, but their part is that it is something very wrong, irrational, or it is Wednesbury unreasonable, as we call that. So it's a higher threshold than an order being considered as right or wrong. So it's not that simple. Sometimes there can be a wrong order, but the judicial review threshold does not permit that to go through a full hearing, and the judicial review claim is refused. It is very important that the judicial reviews are prepared with great care, and the provisions of law and the procedures and policies, everything is dealt with in the grounds, but the grounds should not be too elaborate. They should not be uh, very long. There should not be a very big bundle. It can be a very to the point and a crisp presentation of the dispute and of the grounds why the dispute should be decided in a certain manner. So I wish you good luck with your judicial review if you are coming. And if you need our help, please do let us know. Thank you very much.